Hi, I'm Mark Skoultchi, Managing Director of Catchword, New York. In this how-to video, I'm going to introduce you to some basic trademark principles and provide you with some practical advice on how to choose a strong and protectable name for your product or your company. For a more thorough explanation of intellectual property law and how to protect your names, I strongly encourage you to purchase Nolo Press's Trademark Guide. It's now in its 8th edition, and consult an intellectual property attorney. But in the meantime, let's go over some basics. Let's say you've got marketing responsibilities over a new line of healthy snack foods. You don't eat anything healthy yourself, but you're charged with developing a name for your company to do heart-healthy family of snack foods. You decide to risk your job by developing a name for the line yourself, instead of consulting a naming firm like Catchword, and you've come up with the name Snacktives. It's not bad. At least from a marketing perspective, it seems like a good creative solution. But you're no dummy. You know that a great name is only great if it's also available as a trademark. So, wisely, you decide to investigate to see if the name is already being used for a similar product. You decide to do some legal due diligence. But where do you start? Here are a couple of very basic things you should keep in mind. For starters, it's important to understand that trademarks are grouped into 45 different international trademark classes, or descriptive categories. There are 34 for products and 11 for services. Generally, and in order to protect your trademark, you only have to register your name in the class or classes that are relevant to your business, product, or service. In the case of snack foods, you'll need to register the product name in Class 30, Staple Foods. But you won't have to worry about Class 25, unless it's food you can wear. Class 25 is specific to clothing. However, when considering what classes to register in, you should try to be as forward-looking as possible and anticipate likely extensions of the brand name. Maybe tasteless but healthful snack foods is just the beginning for your Snacktives line of products. Maybe you're imagining a Snacktive energy drink or healthy lifestyle classes that leverage the Snacktive brand name. If that's the case, you'll probably want to register the name in the light beverages class, Class 32, and maybe the education class also, Class 41. Okay, now let's assume you've identified the trademark classes in which you're going to want to register the name. Again, putting your job on the line, you decide to do some preliminary screening in those classes yourself to see if anyone else is using Snacktives for similar products or services. Nope, no exact hits. So you sit back feeling very self-contented and confident that you may actually get a raise this year. But slow down, partner. Don't buy that expensive new e-reader just yet. Even though Snacktives isn't already in use, something similar may be. Something so similar that a customer may actually be confused by the two product names. Luckily, you've watched this video and you know to expand your screening to include not just Snacktives, but names similar to Snacktives. And darn, when you look at that, there's a registration for the name Snacktions, and it's described as a healthy snack food product. At this point, you need to ask yourself, is it likely that a customer with a craving for Snacktions might mistakenly purchase Snacktives instead because of the similarity of the names? If so, you probably have a likelihood of confusion. You should probably eliminate Snacktives, painful as that may be. Keep in mind, similarity in sound, appearance, and meaning may not be the only factors that courts consider when trying to determine the likelihood of confusion. Otherwise, we couldn't have a Ford Explorer and an Explorer internet browser, or an O magazine and an O line of organic products. Other factors the courts consider before finding a likelihood of confusion, they can include the distribution channels, whether the products or services compete directly, how distinctive the marks are, if the names share the same customer base, and even cost. So if you ask yourself one question when assessing your names for availability, ask yourself this: would a customer likely confuse this product for another existing product in the market and make a purchase mistake? Now, let's assume you never came across Snacktions in your screening, and Snacktives is still very much a potential name for your line of chalky, chewy, generally unappetizing health food snacks. In fact, even after submitting the name to your attorneys for further review, it appears that Snacktives is a winner. Hey, and that's great, congratulations. Now your concern is not so much mistakenly using a mark that someone else is using, but making sure that Snacktives is a strong mark itself. In other words, making sure you can protect Snacktives and prevent other marketers from using the name for similar products. This is actually a consideration that most naming professionals make early on in the process when they're developing their name ideas, but we've probably been doing this for a lot longer than you have. Remember this: the more distinctive your name, the stronger and more legally protectable it is. Of course, this begs the question, what does it mean to be distinctive? Is Snacktives a distinctive name? Well, as always, the courts use a number of factors to gauge a name's distinctiveness, including if the name is coined, such as Snacktives, which is a pretty clever coining of the word snack and active. Also, how to create the combination of word parts in the name. For example, Whole Foods. And if the name carries other meaning, for example, a name like pea in the pod for maternity clothing. Also the visual identity. Think of a name like Yahoo and its identity. And if the name is of an arbitrary nature, so consider Orange for a bank. Creating strong trademarks means being able to protect that trademark from other people using it for similar, and in some cases even dissimilar uses. If your objective is to be unique in your space, and also to preclude others from using your name, it's important to create as distinctive a mark as possible. So, to summarize, know your relevant trademark classes and consider how the brand may be extended in the future. Avoid names that would create a likelihood of confusion with another existing product. And try to create strong, distinctive marks that will be easy to protect in the future. Those should be your 3 key takeaways. Again, I'm Mark Skoultchi with Catchword. I hope this has been helpful, and good luck with all your naming endeavors.